Coming up on 8:38 now, Supreme Court justices this fall will consider taking up a case that could lead them to overturning a landmark decision that gave marriage rights to same-sex couples all across the U.S. This comes after a former Kentucky County Clerk, Kim Davis, formally asked the Supreme Court to overturn the 2015 decision. Davis was jailed for 6 days back in 2015 after refusing to issue marriage licenses to a gay couple on religious grounds. Davis argues First Amendment protection for free exercise of religion immunizes her from personal liability for the denial of those marriage licenses.
All right, joining us now, our chief legal analyst, Khalif Rhodes. Khalif, this could be a landmark case here, depending on how the justices rule on this. But can you talk about the argument here from Kim Davis and her First Amendment rights, saying it goes against my religious beliefs to give this marriage license, but also her duty to do the job?
Well, first she has to be able to get it in front of the Supreme Court. You have to be able to get cert granted. To get cert granted, you need 4 folks that want to hear the case. I should say, the couple that was married, that it was at the root of this case, David and David in Kentucky, their attorney said that no court, no judge, U.S. Court of Appeals or District Court judge wanted to hear this case. Her appeal has been denied. Her petition has been denied in all of those locations. So now the last ditch effort is to go to Supreme Court. Typically, historically, looking back at precedent, if a case was denied a petition in District Court, if a case was denied a petition in Court of Appeals, it would be almost a 99% chance that that case would have no chance of being heard by the Supreme Court. Not this case. I can say that you need 4. We already have 4. Looking at the original opinion, Justice Kennedy, he's no longer there. He wrote the opinion for the court, but we had some dissenters. Roberts dissented. Scalia dissented. He's no longer there. Thomas dissented. Still there. Alito dissented. Still there. That's 3 justices already that dissented from that opinion that are still there. So then you have other folks that have made comments in the past that want to talk about it. You only need 1, folks. The majority has shifted now 6-3. So you would think out of those other folks, you got 1 vote to at least get it heard, to be able to have an opportunity to discuss it. Clarence Thomas, in the Dobbs decision, said, I want to readdress this case. So I think that the writing is on the wall, that even if you're looking at precedent, this case would not make it in front of the Supreme Court. But if you're looking at the raw numbers, it's clearly heading for the Supreme Court.
And so I know this is a 10-year-old case here, but Kim Davis, the former county clerk, says she should be protected under First Amendment rights for her religious freedoms that were violated. How does the court balance those religious freedoms versus the constitutional guarantee to the to marriage equality?
First Amendment rights versus equal protection is what you're asking, and that's the argument the court will have to unpack. I think that her attorney is attempting to play into a number of things, and specifically attacking the words of Justice Kennedy. He said that Justice Kennedy's opinion was legal fiction. So I went and read Justice Kennedy's opinion, and I'll be honest, sometimes these opinions can put you to sleep. This was not one of them. It was masterfully crafted, and it laid out the foundation of what marriage means to us as people and as American citizens. He starts off by saying that we've long held, this court held, that the right to marry is protected by the Constitution. And then he goes into the Loving v. Virginia. If you're unfamiliar with that case, that's at the time states had banned interracial marriages. So Loving v. Virginia in 1967 was when they decided to invalidate those interracial bans. And he says we held in that court that one of the most vital personal rights essential to the orderly pursuit of happiness of free men is the right to be married. And so the court will, in essence, have to address that claim, because if you overturn Obergefell, which is this case that we're talking about here, you're in essence saying that that's not a right that you are guaranteed to have underneath that equal protection. And also balancing that 14th Amendment, that First Amendment free speech protection. I think the court will have to have 2 different arguments, which is she does have a First Amendment protection, but these folks also do have a 14th Amendment protection. The court, I think, if I'm playing, looking at my magic
crystal ball,
right, I think it would go to that they'll kick it to the states. That typically what this court has done is said, I don't think the federal government has the responsibility or the requirement to determine who should be married, i.e. who should get an abortion.
Right.
So now I'll say each individual state should make that determination. So you would think they'd say that the 14th Amendment doesn't protect this, and the states can make a determination. So I'd say this is the scenario.
So
in California, basically, you'd have the right.
Right.
But maybe in North Carolina, you don't have the right. That's if you're looking down the road and looking at the next step. That's what happens if you kick it back to the states.
So let's go ahead down that path there. If the Supreme Court decides to kick it back to the states, Khalif, in your time, do you think you've ever seen a Supreme Court where there's so much, I guess, deference or turning away from case law, from precedent?
Yes, Roe v. Wade, Dobbs.
Well, I'm saying
you had 60 years,
you pack those
right?
two in together and saying like this Supreme Court, the current makeup, where they would have gone against two historic landmark decisions.
Yeah, I mean, that's probably the one that had significantly more. You're talking about 60 years of precedent. This has a shorter time frame. You're talking about 10 years of precedent, but it has been supported throughout that 10 years, even against attacks. The problem that I can see is this court, the temperament right now is to make drastic changes. And so this Roberts court will go down in history as a court that was not scared to tackle large issues, but when it goes back and looks through it, they may have rushed on some of these issues with these emergency hearings that we've had. And in this scenario, this won't be an emergency. This will be a full-fledged hearing, but I think it will have a long-lasting impact on almost 500,000 folks that are now same-sex marriage in our country. Yeah, those are the folks that this case will directly impact, and the people that are expecting to have those same opportunities.
All right, a lot of eyeballs will be watching this case for sure. Thank you very much. Appreciate it, Khalif.
Queen City News Plus. Just search Queen City News on your smart TV's app store.